So I want to discuss the issue of employer liability. As I mentioned in the video above, Ontario has an odd exception for employer liability for sexual harassment complaints. So the basic structure of the law across Canada is based on a Supreme Court of Canada case called Robichaud versus Treasury Board. And that case basically said the employer is responsible for all workplace violations of a human rights nature. So that's the fundamental principle. And then, if the legislation of each jurisdiction wishes, it can change it. So that is indeed what has happened in many jurisdictions. These jurisdictions have created an exception to the general rule that's created what's called a due diligence defense. So basically what that means is the employer is presumed liable, but if it can come to court and say, hey, this is what I've done. I try to create a safe workplace. I've created workplace policies and procedures. I monitor them. I make sure everybody's doing the right thing. Basically, I'm a pretty damn good employer, and I've done my best to create a safe work environment. Then in that situation, there is the right of the court or the administrative body to let the employer off the hook for this complaint. Again, for that reason, it's probably appropriate when you're considering a sexual harassment complaint in any jurisdiction is to name the individuals personally. Now, I mentioned, excuse me, other exceptions in Ontario. The same exceptions apply to every jurisdiction. So let's repeat them just to make sure you get it right. First of all, if the individual is the controlling mind of the corporation, that is, the grand poobah runs the place, big shareholder, boss man, then there is an exception, and the employer can be held responsible for the acts of the grand poobah. That is, the individual and the corporation may be both responsible. The second exception is what I refer to as the general reprisal. Basically means that the employer was aware of a complaint that was to be made or was made by an individual and takes adverse action against that person, termination, demotion, whatever it may be, then the employer has direct liability. And the third exception is one that I've forgotten about momentarily, and it come to my mind, is a poison work environment. So basically, the poison work environment is the opposite of the due diligence. So if the employer has clearly allowed the workplace to be in an intolerable state and has shown disregard for creating a safe work environment, then the employer may be responsible in that category for a workplace sexual harassment complaint. So beware of all these things. The civil courts have different rules, but these are the rules under the administrative process under the human rights legislations. Thank you.